little moans out there. He says, I appreciate the opportunity to address the group on RJA. It is probably the worst bill passed in North Carolina in a generation. I've been opposing it and working for its repeal since its enactment in 2009. This is an incredibly crucial issue for us, and it should concern every freedom-loving person. Please, let's support Jeff and this effort, and I'm going to turn this over to him and let him explain all of this, and then we can figure out what we can do to support him.
Thank you, Jane.
You're welcome.
Got about 10 handouts. No, what good is a talk without handouts? Here's some. Here you go, Fremont. There's way too many. Yeah, there's way too many. That's why there's. Here's the last one. That's the most important one. No, that one, that's the one that doesn't go.
Oh, okay. I see what we're doing.
Each one of them has the same, each file has the same thing.
So his is the same as mine?
No, each file has it. There should be about 8 or 10 different handouts. I'll get started while they're handing that out. I want to thank you again for the opportunity to speak to you. And in spite of the congressional race and how that turned out, I always feel like I'm talking to friends when I come to Tea Party groups, wherever they are. And I'm going to speak without a, I'll just leave the mic here. I think it'll pick me up. Unless you all, if you can't, feel like you can't hear, raise your hand as we proceed and I'll use a mic. I want to talk to you about the Racial Justice Act. North Carolina, well, first of all, I'm the DA, as Jane mentioned. I've been the DA in those 3 counties for 18 years. I unseated an entrenched Democrat in 1994, and I'm the first Republican to be the DA in the district that I have since the 1920s. Originally, when I ran, I had 5 counties, which included Henderson, Transylvania, Polk, and McDowell and Rutherford. And in 2006, the legislature, the Democrat legislature, split my district, or our district, and split off McDowell and Rutherford into its own district. So I now have 3. I'm your DA for 3 counties, and I run again in 2 years. Since 2008, really, we've been fighting this unfortunate situation with the Racial Justice Act. And I would tell you, many of you here are cynical to some degree about some of the politics that goes on both in North Carolina and elsewhere. But the Racial Justice Act, picking out that name for a bill it makes it extremely hard to challenge the actual content of the bill, as you might imagine. Who could be against racial justice? And of course, North Carolina district attorneys, there are 44 of us. It is our job every day to make sure that racial justice is a part of our justice system. One of the things that Jane and Fremont are good enough to be handing out is an article that Civitas ran that I authored back in probably 2010. And it lays out a lot of the points about this Racial Justice Act. And I'm proud to tell you that when the Republicans took over the House and the Senate, I went down there last year, and a lot of the General Assembly members who were Republicans had in their hand that Civitas article about the Racial Justice Act because they realized it's a bad bill. I guess the way to get started with the Racial Justice Act, in fact, I guess the best way to get started is for me to list what I've handed out to you, and I'm hoping that you will carry each one of these 10 handouts with you so that you can take a look at them and maybe digest some of the things that I'm saying today about them, and then you can look in turn at the handout. What we're handing out is a copy of the North Carolina death penalty statute that's in effect now, a copy of North Carolina's Racial Justice Act, which was passed by an all-Democrat vote in a Democrat-controlled House and Senate, and a Democrat governor signed it in 2009. There is a 2-page statistical argument that was put forth by the district attorneys in North Carolina that kind of puts the statistical problems into focus. There's a news release that I issued years ago that lists off the top of my head about 10 different protections that every defendant in North Carolina has in spite of their passage of the Racial Justice Act. In other words, North Carolina has a very involved network of rights that every defendant has, where they can raise the question of race and other things. They don't have to have a Racial Justice Act. They could have raised racial bias in about 10 different ways before the Racial Justice Act was passed. There's a Duke study of several Florida murder cases. I don't think they're murder cases. Several Florida criminal jury trials that was done by an economics professor over at Duke, and I'm afraid that it tells us some of the problems that we're going to run into as we proceed under this Racial Justice Act. I also, for fun, put in there the Racial Justice Act has no definition of race. It doesn't tell us what race is, and I put in the definition from a couple of dictionaries of race and racism, and you'll have those, and you'll be able to tell after you read those definitions. You know, the Tea Party has been accused of being racist, but you'll find by the definition that not only did you already know that you're not racist, but if you look at that definition, it'll pretty much tell you that you're not racist just because you're in the Tea Party. My Civitas article is in there, and then the amendment that is under consideration tonight in the legislature. They're talking, in fact, they went into session tonight, both the Senate and the House, I believe, and one of the things they're considering is an amendment, and we'll talk about that before we're done. And then there's finally a letter that we, Conference of District Attorneys, drafted and sent to the Democrat Governor Perdue, asking her to support the amendment that's being considered as a compromise, at least, that gets us down the road towards improving the Racial Justice Act. Now, if you take those things with you, after we talk tonight, I think you'll be able to look at those things and get a feel for what this is about. In 2009, the Racial Justice Act was passed, as I mentioned, by all Democrat legislators. I don't think there was a Republican who voted for it at any level, and it was signed by the Democrat governor. North Carolina is the only state in the country that has a Racial Justice Act that has the language that ours has. A couple other states, Connecticut, not Connecticut, but Kentucky, for example, has a statute called the Racial Justice Act, but it doesn't look anything like our statute.
Jeff, who authored the original piece of legislation?
Well, I don't know which Democrats. A couple of the Democrat legislators from down east, yeah, I think it comes out of a couple of the black legislators down there. And here's what has happened. Well, let me ask you this. How many of you support the death penalty in some cases, in some horrible cases? Okay, you'll be interested to know that historically, about 70% of North Carolinians support the death penalty in the most horrible cases. And that has been true for 30 years in North Carolina. That percentage holds very steady over the years.
White-collar criminals.
We have a death penalty in North Carolina, and the statute in North Carolina says that you can't even be considered for the death penalty. Thank you so much. Would you just put it back? You can't even be considered for the death penalty unless statutory aggravating factors are present. And I won't get into it now, but it's in the statute, that's the death penalty statute, I think it's 15A 2000 that you have. Did you not get them for yourself? I hope you keep them. That statute lists aggravating factors, and essentially it's the things that make a death penalty case rather than a life in prison case. And they're the things that you might think. In a torture case, for example, or in a case where we have felony murder. So if somebody is committing an armed robbery or committing another felony and they kill somebody in the act of committing that other felony, then they're considered for the death penalty. You know, the things that you and I would think would be the most violent and horrible facts that might be included in a murder case are what make a case a death penalty case versus a life in prison case. And that's very important. That's the way our statute has been set up for as long as I've been. Well, not as long as I've been, but certainly for the last 25 or 30 years. So what has happened is that 70% of us support the death penalty. We've written in most, our statute about death penalty is very similar to other states, because the U.S. Supreme Court has told us what has to be present and what you put in a death penalty statute. So when you read that somebody has gotten the death penalty, usually it takes about 18 years for them to even get to the point where they might be going in to be executed. All in North Carolina, it's even longer than that. But if you see that somebody has gotten the death penalty, it means that that was one of the most horrible cases that you can imagine. And the death penalty statute is set up so you have a trial on the guilt or innocence of the defendant. The district attorney has to make a decision as to whether there are these aggravating factors. If there aren't aggravating factors, then it's not a death penalty case automatically. But the DA makes that decision after looking at the facts and looking at our statute. If you see somebody's gotten the death penalty, it is a horrible case, I can tell you. You don't even need to read what's in the paper about the factual setting. You can guarantee, you'd be guaranteed it's a horrible case.
Can we add factors to it?
No, the statutory factors are somewhat general, but they're the horrible things. For example, the word torture is used,
Torture,
and that can be a lot of different things.
Well, white-collar criminals destroy people's lives.
Yeah, well, we're stuck with our statute, and it doesn't include that, and I'm in full agreement with you. In fact, our district is one of the several in the whole state who really focus on white-collar crime. Death penalty has evolved, and in 2009, well, let me go back to 1987. In 1986, there was a U.S. Supreme Court case that said no longer could DAs, when they're picking a jury, use race. They couldn't remove a juror just because of his race. They had to have a legal reason to remove a juror. In the past, before that, you had something called a peremptory challenge. You had 6 peremptory challenges in a murder case, and you could use those for whatever reason. You didn't have to give a reason. Now we cannot use those for race. If you remove a minority juror, you have to have a reason other than just a peremptory challenge. You can't use a peremptory challenge on a minority anymore unless you have another underlying reason. And then it's not a peremptory challenge. So that case came down from Washington, the U.S. Supreme Court, in 1986. In 1987, a murder case in Georgia got up to the Supreme Court, the U.S. Supreme Court on certiorari, and in that case, a black man murdered a white man in Georgia, and he was convicted and given the death penalty. And a series of professors in Georgia did a statistical study, and when the case got up to the appellate level, they started talking about whether you could prove racial bias by general statistics. And what they had was a study that basically said that in Georgia, if you're a minority, you've got more of a chance of getting convicted of the death penalty than if you're a non-minority. And they had a statistical basis for this, which was bogus, very bogus. And the case is called McCleskey versus Kemp from 1987. And it's too thick to have included it in your handouts, but you might Google it if you want to take a look at it. In that case, the defendant had general statistics, and what they were trying to show was statistical percentages, racial percentages. If the population of the county had a certain number of minority, a certain percentage, and there were more of that minority, a higher percentage on death row, then that was considered evidence, general statistical evidence of some kind of racial bias. The McCleskey court, 5 of the 9 Supreme Court justices ruled that general statistics like that cannot be used to show that there's a risk that you might be more liable to be convicted and get the death penalty if you're a racial minority. Yes?
What happens to being judged by a group of your peers?
Well, I mean, that's part of our jury
I'm not
system.
saying I'm racially biased or whatnot, but
Well, we're going to get into that if we have time, because that's really, you just put your finger on one of the big issues of this whole thing.
I think so.
McCleskey says we're not going to we consider these general statistics of racial percentages as being non-probative. So they struck down the Baldus study, B-A-L-D-U-S, I think it is. They struck down that study, and this was 1987. So the other thing that McCleskey said, the court in McCleskey, was that showing general racial tendencies for racial bias across the state is no good. If you think you had racial bias in your death penalty case, then you need to show evidence of racial bias in your case, not evidence in somebody else's case on the other end of the state, or not general evidence about statistics in cases other than yours. So in other words, if you're going to show racial bias, you have to show that the DA was racially biased, or that one or more of the jurors was racially biased in your case, not these general statistics. So that was good law for, and still is good law for virtually every state in the Union except North Carolina. One of the things that was a tripping point in McCleskey was at the very end. The opinion says that, look, the courts, we don't want these, we're not going to accept these general racial percentage statistics as probative evidence. But they added this language, something like to this effect. They said, courts anyway are not really the right place for statistical data like that. They said the legislatures of each state are more set up to be, are better prepared to be able to look at statistics and evaluate them, and they represent the people of the state. And so if you're going to make a statistical argument of generalities, don't do it in court. Talk to your legislators, which is, you know, how many times, I know I've said 1,000,000 times to groups like this, don't argue with me about how short the sentences are for things. Talk to your legislator. And that's essentially what the U.S. Supreme Court justices said. Well, we thought that put the whole thing to rest, and by now I'm old enough to have been practicing when some of these old cases came down. Not in North Carolina. That sentence about ask your legislators to take a look at it, unfortunately gave rise to the 2009 Racial Justice Act in North Carolina. And although we call it a Racial Justice Act, it's the furthest thing from worrying about racial justice. Those of us who are in the prosecution business work every day to try to make sure that race does not come into any criminal case. It's got no place in criminal law. And since the 1500s, Lady Justice has been portrayed as having a blindfold on because of the very reason that we want justice to be blind. We don't want justice to take race into consideration in any manner, whether it's a death penalty case or otherwise. But essentially, the Racial Justice Act, the reason it's so despicable is probably the word that comes into my mind, is that it essentially says this. Now, for the first time in North Carolina, and we're the only state that has this, you can use these general statistics of racial percentages as evidence to try to convince the court that you should get a life sentence. Even though you got the death penalty, it should be converted into a life sentence because there was racial considerations were a significant part of your case. That flies right in the face of the McCleskey holding. All the other states that I know of in this country have followed McCleskey right up to the very minute. In fact, Kentucky's the one that has the Racial Justice Act like us. They have the name, but their statute essentially follows McCleskey. So we're the only ones who departed from McCleskey, and the design of our statute is designed to get around the McCleskey opinion. So our statute says, A, you can put on these statistics. B, you don't have to be concerned with just your case, whether there was racial bias in your case. In fact, it's set up so that if you showed racial bias across the state, not necessarily in your case, you could still prevail and get your death penalty converted to a life sentence. It says you can use these statistics and look at either the county that you were convicted in, and if that doesn't work, if you can't find some statistical way to argue in the county, then you can go to the region, the judicial region. That's going to be a multi-county area. Or if that doesn't work, you go to the prosecutorial districts. We have 100 counties. We have 44 prosecutorial districts. So just like our district has 3 counties, most of the districts are multi-counties. If that doesn't work, then you can jerry-rig some statistical data for the whole state. So you no longer, it runs an end run around McCleskey. Under our statute, you don't have to be concerned with just your case. You can use the general racial statistics that McCleskey, the ruling in McCleskey said were non-probative. And worse than anything else in this statute, our statute says you can use these general statistics and you cannot argue that the prosecutor cannot bring in any evidence of these aggravating factors that I mentioned to you earlier. You can't look at the aggravating factors in your particular case where this motion was filed. You're only allowed to look at racial percentages, or if somebody comes in and admits that they convicted so-and-so because of his race, which I don't think that happens in North Carolina anymore. I don't think that's happened in a generation or two. But anyway, our statute says the very thing that made this guy's death penalty a death penalty case, the statutory aggravating factors cannot be looked at or considered in determining whether racial bias was a significant factor. So you can see why DAs across the state and any prosecutors who really have read the statute and understand what's going on here are alarmed. And so we've been alarmed since 2008 when this started to be considered. We're the only state who has it. And a person like myself who comes into a group like this and argues against the Racial Justice Act is already branded as a racist. But the problems with this statute are really, and you started to put your finger on it. The problem is that the statute substitutes the possibility of using raw racial percentages or quotas and inserting those into death penalty cases in North Carolina. In other words, if you can create create an argument that there are more of a particular minority in the county you were convicted, or statewide even under this statute, or a lower percentage of minority in your county or state than the percentage of minority on death row, then you've automatically got evidence of racial bias to be considered under the Racial Justice Act. And that's precisely what the case in McCleskey said is no good. In fact, now the people who have sponsored the Racial Justice Act and the groups that were behind it in 2009 have marched out a study very similar to the study that the McCleskey court struck down, and they're trying to force that on the scene in North Carolina and use that to argue in favor of the Racial Justice Act. And they've succeeded in one case in Cumberland County. The Superior Court judge has bought that hook, line, and sinker, and based on general statistical data in their study that he has already converted one death penalty in Cumberland County, that's Fayetteville, to a life sentence. Now there is tonight in Raleigh is a compromise bill which goes a long way towards curing a bunch of these things. In fact, it cures everything that you and I would want. It comes just short of repealing the Racial Justice Act. And of course, prosecutors since 2009 have argued, like myself, that repeal is the only way to get us back to where we were under the McCleskey. We were following the McCleskey case, just like every other state, prior to 2009. So the 44 elected DAs in North Carolina have been pushing for repeal. Well, the Republican General Assembly last summer passed a repeal bill. It was an amendment, but it basically repealed the statute. And it was passed by the House and the State Senate, and it was vetoed by the Democrat Governor Perdue. And then ever since then, the Senate has had enough votes to override the veto, but the House has not. The House needs about 4 or 5 Democrats to jump in with the Republicans to override that veto, and it doesn't look like that's going to be able to be done. So they introduced this compromise bill, and it got passed with some Democrat support. So I think if it passes, it's going to go a long way towards rectifying this, but it won't go all the way back to where we were. And the one important thing that will remain, the compromise bill says you can't look at statewide statistics. They're not probative because they're general statistics and they don't affect your case. You cannot look at the judicial region. You can, however, look at general statistical evidence in your county where you were convicted or in the prosecutorial district. So in our case, and by the way, we have either 3 or 4, I think we have 4 people on death row from my district, and we have a racial justice motion filed in each one of those. Even the white, 3 of them are white defendants, and they filed. So it says we will still accept these general statistical percentages as some evidence. But the compromise bill also says no longer can you get there on just statistics. You have to have something else. And it also has removed that language that says you cannot consider the aggravating factors. So under the compromise bill, we'll be able to consider those aggravating factors and put on evidence of those to show why this is a death penalty case and that race didn't have anything to do with it. It was the horrible facts of the case that made it a death penalty case. Those are all great things. The one thing that I have, the fault that I have brought up with this compromise and what I'm alarmed about is that it goes a step way further than McCleskey, and it says these same kind of statistics that the McCleskey court struck down as being non-probative will now be considered as some evidence of racial bias in North Carolina in the county or in the prosecutorial district where the defendant was convicted and given the death penalty. It sounds like a small thing, except you put your finger right on it. If you're going to use these racial percentages as any kind of evidence at all that could be probative, even though you have to put on other evidencing in addition to these statistics, what you're saying is racial percentages have at least some place in considering criminal death penalty cases. That's what this thing is really telling us. And your point about the jury is very well taken, because the study that I have handed out from the Duke economics professor is brand new, and the article that I handed out that mentions it is hot off the presses. I think it's from this month in a Lawyer's Weekly magazine. This study looked at some Florida cases that were non-death penalty cases, and they reached the conclusion that I doubt is accurate, but they say that if you're a minority and you're facing a jury that's all white, that you have about I guess a 10 or 15% more chance of getting convicted of a criminal charge than if you have at least one minority on that jury. And I don't believe that, frankly. It may be the case in Florida, but I don't think that's the case in North Carolina. But what the point I'm trying to make, and you started to bring it out, if I hadn't stopped you, I think you would have. If we're going to take these racial percentages, what I'm worried about is that we're going to start, once again, looking at quotas, and we're going to, if we follow this Duke study, they're going to press for a law that says that you have to have a minority on every jury of 12. And if you have 10 or 12 or 15% of that minority in your county, you're going to have one of your 12 jurors. If you have 40%, you might have to have 40% of that jury or something close to that. That would be a quota system in jury selection. Now, we use quotas in employment law. You know, Title VII is the 1964 I was going to call it the Voting Rights Act, but it's more. It's a Civil Rights Act. Thank you. It transcends just voting. So the 1964 Civil Rights Act said that it outlined a bunch of racial discrimination, and it outlawed those. And one of the things was it outlawed employment discrimination based on race and based on gender and a bunch of other things. If you recall, what happened with that aspect, the employment law arena, was that employers started taking a shortcut, and they started just hiring. If you had a factory and you needed 100 blue-collar guys to work on the line, like I used to work at steel mills in the summertime. Say you need 100 of those. You can't just hire the first 100 guys who come in if they're all non-minority. You got to have some minority representation in your hiring. So what was happening was employers said, "Well, hell, we'll just do we'll just establish a racial quota. So if Ohio has 15% minority in their general population, we'll hire 15% of our 100 steel workers. We'll hire 15% minority." Well, that's illegal, and so that was the quota system, and it should be, is right. But we got dangerously close to considering quotas as living up to the employment discrimination prohibitions that are in Title VII. It's not. It is against the law to use quotas. It doesn't matter which side of the argument you're on. In employment law, you can't just use quotas. You do have to try to hire a minority, but you can't just say, here, we're going to do 15% or 18% or whatever. And that was the natural outgrowth of the employment law, discrimination law, that was in Title VII. And I'm afraid that that kind of concept is starting to work its way into our criminal law system if we're going to allow these general statistics of percentages, racial percentages, as having any probative value in a criminal case. Then we're moving down that track, as they say, the slippery slope. Now you had another question.
Well, it's been for decades now divide and conquer with population. I think it should be totally illegal. Only the federal government seems to be getting away with classifying people. Every day I apply for a new job, and every day there's a little box. Decline to the only thing I'll claim is things I'm actually responsible for, like I'm a vet and something else. For something you were just born this way, it's not something that should be.
Justice, certainly in the criminal arena, it shouldn't be considered in any arena, should it? But certainly not in criminal law. So Lady Justice should continue to have that blindfold that she's had since about I think it was in the 1500s that started to be added to Lady Justice. So this idea of quotas, we've got to fight against it creeping into our criminal law system. It already started to creep into employment law, and it was outlawed, fortunately.
Yeah.
But there was a big monumental fight about it, by the way. Some people thought it was okay to use racial quotas in hiring, both from the federal government side and from the employer side. They thought that was a good shortcut.
Well, I think a business person, if he's a smart business person, he'll hire the one who's the best candidate for the job.
But if he's going to keep
a private owner, if he wants to hire all green people,
I know it.
he should be able to do that.
We know we're stuck with what the federal law is. Unfortunately, this idea of quotas has started to creep in. There are still arguments today about whether the employment law under Title VII, as it's evolved, does in fact create a de facto quota system for hires. And that argument continues. And what I'm saying is, we really need to repeal the Racial Justice Act entirely, or we need to add language to the amendment that's not in there right now that virtually strikes down these general statistical percentages that they're going to use.
I don't understand why race would even enter the deal. If you did a crime, you did the crime.
Juries that I look at
what
today
race you are.
do not factor race in. I'm convinced that they do not factor race into the equation.
Another question is, you said there was 3 whites that had filed for something. Is that because there was only...
No, there are more than probably 3/4 of the, or maybe 60% of the people on death row are non-minority, and almost all of them have filed racial justice motions to try to get their death penalties.
Were their juries all white?
Well, they were a mixture, just like they. And I'll say this, and this is, I like what I'm about to say to you, and this is, if you remember, I said when we got started, and I don't know how much time we got, Jane, I've already gone over, I'm sure.
You're fine.
You know, I said that, I pointed out that
then you'll know.
the Racial Justice Act, the statutory language, does not define what race is. And so that sounds like a stupid thing until you really think through it. And look at our mountains now. I now, and when I say that, look at the marital couplings that are occurring in our mountains.
We should have put a fence up around North Carolina.
And, well,
Too late now.
yeah, that's vis-a-vis the other states. But what I'm trying to say is there are a larger and larger, or there is a larger and larger number of people who refuse, like you do, to check a racial box on any kind of form. And there are a lot of mixed race people in this country who do not regard themselves as being one race or the other. And here's the federal government trying to get you to check that racial box on every doggone form that there is in the world. And we get a lot of jurors now. I'm not saying this is, the majority of jurors, but especially younger jurors will not, when you're trying to select a jury, they won't acknowledge any kind of race. And I don't think they should, unless they want to. And so that is becoming an issue too. So I think what's going to happen is ultimately in a couple of more generations, I'm very serious about this, race is, it's not going to be an issue. But it still is now with some people. And so they're going to use any excuse they can to get off a death row. And really what we've argued is that this is a backdoor way of trying to repeal the death penalty in North Carolina to make it so expensive for all this analysis. And right now the Conference of DAs is trying to get another study that will put all this into the right frame of reference to show that we're not all in this room and we're not all prosecutors racist. So those are huge expenses for the taxpayer. There's about 158 of these racial justice motions, all of which need to have hearings, and all of which are going to have experts, statistical experts, and new studies, and professors here and professors there. And you and I are the ones who are footing the bill. And it's all because somebody wants to repeal the death penalty in North Carolina, and they know they don't have the votes to get it done outright. And so these things get legs on their own, and now we've got a Racial Justice Act. We're the only ones in the country who have it framed like this, and we have very close to a creeping quota system if we're not careful. Jane.
What can we do, or how do you see our role in trying to remedy this?
Well, it's a fact of life that the more connections you have in terms of communication connections to our legislators, the better off. And they now have email. And I tell you, the elected district attorneys last week sat on their hands when Representative Stam shepherded through this compromise bill that I was talking to you about. We were going to support it, but we looked at it, and the problem that I mentioned to you about still accepting, even much less, but still accepting that concept of racial statistics gave us trouble. So we sat on our hands last week, but I'm driving tomorrow morning down there, and I'm not so sure I'm not going to sit down in Representative Stam's office and say, at least I'll support you if you can get the compromise done, and then we may try to repeal it next summer. Because it's a bad idea to have general racial percentages enter into any kind of criminal case. I can't see that. So I would say, Jane, we know who our legislators are. We now can email them. And I would say that if they really, sometimes they don't, well, most of the time they don't read their emails. I don't want to speak for them. But somebody in their office does. And I would start with the Speaker of the House. And it's the House where we've had most of the problems. But I'm going to speak to Senator Apodaca about it too, because I want to make sure that the Senate doesn't shoot down this compromise. If they're going to go down that road, they need to support it all the way. Otherwise, it'll be vetoed and it won't survive a veto. But I would contact your local legislators. I would contact the Speaker of the House and the Senator Berger, who is already on the right side of this.
So what you're saying is that the message is that you want us to support this amendment?
I would support the amendment, and with the proviso that we feel like it ought to be repealed next summer by the new legislature. Okay. Or
so
we'll work. We'll try
message.
the compromise and see if it works. You know, the compromise is so much better than what we have now that I'm afraid we ought to grab it and then try to repeal what the rest of it maybe the next time we get them in session. So I think it's the compromise is way better than what we had.
Okay, and they're doing this tomorrow?
They're considering it tonight and tomorrow. Yeah.
What is the basis of the white guys? I'm sure they're all guys. What is the basis they're filing?
Well, to me, it's proof that the statute is bogus. I mean, it's proof that it's a bunch of BS, because they're following what I said earlier about the general percentages. Their view is if they can show that minorities are disproportionately convicted, then they're going to use that as a general argument that everybody's racist in our criminal justice system and that they ought to be off of death row too, because we are a racist society. And some of the motions have language in them. I got one eye, and that is knocking it out. Some of the motions, in fact, many of the motions that were filed under this Racial Justice Act have 20 and 30-page narratives about what North Carolina was like in the 1880s and how racist we were in the 1950s. And I didn't grow up in North Carolina, but I've been here since '68. I came down to go to Wake Forest, and I guess there was racism everywhere. I know I was from Ohio, and I didn't realize it, but boy, I didn't grow up with any minorities, and it didn't even occur to me until years later that things were pretty segmented and people stayed in their neighborhoods. Although when I worked in the steel mill, I worked with a ton of black guys, and by the way, we had a lot of fun together.
Unfortunately, the first racism I ran into was 68 here in Sears, with the white and black only fountains.
Well, I know that I had a job in '69 or '70 lined up with a construction company back in Ohio. I was in school here, and in the summers I went back and either worked in a factory or worked on construction. And I talked to the owner of the construction company. It was a friend. His kid was a friend of mine. they had a job set aside for me because I was coming a little later than some of the other schools got out. When I got up there, reported in for the job, they said, "We can't hire you, Jeff." I said, "Well, I thought you were holding the spot." "Well, we were holding it." "Well, what happened?" "Well, the guy from the feds came in here and they told us we don't have any minorities, so we can't make another hire unless it's a minority. So the job we were holding for you, we're going to have to give to a minority." That was the first racism I ran into, and that was in Ohio. But it was in that employment law reference.
Now with the O.J. Simpson, I think was a terrible example. I don't remember what the makeup was of the jury there, but let's say a black individual is on up against a charge for murder and torture, it's a death penalty, or anything. He stole candy. Can he not have a jury of his peers? And if he so decides to have all of them black,
no, he is stuck with the overall group of jurors that they call in there, and there's a very set series of laws that they have to follow in picking who that big veneer is going to be, the big group. And but they're going to be drawn from the community. They're going to be drawn, some people from the phone book, some people from the election registration, some people from the DMV. Nowadays in North Carolina, it's very rare that we have a general big jury pool that doesn't have a Hispanic name, and they don't show up because they're probably not citizens. Well, they're not supposed to be picked for a jury.
But this is a representation of the community. It's not a representation of his peers.
When you talk like that, I'm afraid that we agree generally with what you're saying. Although what happens is that plays into that idea of a quota system, where if a black defendant doesn't see a black person on the jury, or a Japanese or Asian doesn't see an Asian on the jury, he shouldn't have the right, in my opinion, to say there's a quota system in jury selection.
He has the right for jury of his peers.
Well, of his peers has been interpreted for hundreds of years as being a general representation of the population, not according to racial percentages, but according to the parts of the statute that they use to select general jurors. And like I said, that's so random that even includes going through the phone book and just picking out names. And you don't know what, I guess, generally you're not sure about a race.
That is all. I see where he's going, and it always has kind of bugged me, because the definition of peers in the dictionary does not fit the definition of the peers in the law.
The reason we don't go as far as you guys are talking about, and I understand the argument, is that if that would boil down to an argument that because I'm Episcopalian and white and maybe left-handed, that's how I define my peer group.
But the thing is that it will eliminate the bias. He has
I don't know if it will or
not.
I don't know if that. Where I would argue with you respectfully is that wouldn't necessarily eliminate the bias. And I would argue to you that I've had minority representation on the cases. I think there's one or two of them in the 5 cases that I used to have, where the defendant was black. I had at least one black juror on there who voted for the death penalty.
Yeah.
So, and it has to be unanimous. So it's you can't. No longer does it break down according to race anyway, because no longer although blacks, as an example minority, continue to vote pretty monolithically, although this time I think they're going to surprise us a little bit. They don't view other things monolithically, and one of them they don't view is the death penalty. Yes, ma'am.
If we have a murder case and we're going to pick the jury,
Yep.
who gets to pick the jury?
There's a set statute that tells us who the clerk can pick for the big jury pool. So they'll bring in 150 or 200 people, and the statutes tell us how they're going to select that big jury pool. And they look at voter registration, they look at property ownership in the tax office, They get names out of the phone book. There's a bunch of other things that they look at. It's kind of a random sampling of that county. You're almost always, in a criminal case, the venue of your case is the county in which the crime occurred, unless there's so much media coverage that a judge allows it to be moved to another county. So it's going to be drawn from the people in your county.
Okay, if you got the defendant attorney, does he get to have any say-so?
Yeah. Oh yeah, yeah. In the selection, when you have the jury pool, which is 200 people, we're going to select 12 jurors as your jury panel. Both lawyers have input into that. And each lawyer has a certain number of peremptory challenges where they can scratch somebody as a potential juror for no reason that they have to articulate, except now, since 1986, under the Batson case, the state does not have the right to excuse a minority juror with one of their peremptory challenges. If I'm picking a jury in a murder case, in any criminal case, and I remove a minority from the panel of 12 as we're picking them, I have to have a reason, like they have to have a criminal record or something like that. I can't just remove them because I don't want a minority on there. Used to be you could do that.
I thought the judge, not the judges, but the lawyers for both sides could have any reason.
No, there's only a limited number of those 6 maybe where you can use peremptory challenge that you don't have to give a reason. Above and beyond those peremptory challenges, you have to have a cause, a reason that juror is not going to be fair. And both sides excuse jurors in the normal process. And in the death penalty selection, the defense attorneys they excuse jurors as to race, but they're allowed to. The state is not allowed to. So there are protections built into it. Yes, sir.
I might be misinterpreting what you were saying, but anytime you have your big jury pool, don't both sides have a thing to reject so many just right off the bat, and then they have
no, they have to. That jury pool they're subpoenaed, and they come into court, and then we pick 12 at a time to sit in there. That's where the 2 sides can. Yeah. When they have that panel sitting of 12.
Isn't there a limit though how many I could reject if I'm the defense attorney?
Yeah. Unless you can find a cause. If somebody, for example, in a death penalty case, if the juror comes in there and says, I'm against the death penalty under any circumstances, then the state's going to be able to remove as many people as say that. There's no limit. Or the other way around. You sometimes have people come in and say, I am not going to convict anybody. I don't like this system. I'm not going to convict anybody. The state's going to want to get rid of that guy. Or a guy will come in and say, I think if you're in this room, in a courtroom, you're guilty already. I'm going to convict you. And we run into jurors like that. The defense gets them off, and that's a reason. They don't have to, that's not a peremptory. That's one of the reasons. So yeah, there's a lot of give and take in that jury selection. So you end up getting somebody who's representative of the community, I promise you. Although I do say that it has become a problem because North Carolina registered so many illegal aliens to vote. We now have jurors selected for the big pool who don't show up, but they have Hispanic names, and I'm presuming that they have North Carolina licenses because we issued 40 or 50,000 licenses to basically minorities, usually Hispanics, and not following the statutes. And RL, you may remember this. Remember Larry Justice?
Probably that many in Madison County.
Well, you remember when Larry Justice and I were raising Cain about that, and right after 9/11, there were a couple names on somebody got the list of driver's licenses that were issued for the 5-year period before 9/11. North Carolina had several of the names of the people who pulled off 9/11 as having been issued driver's licenses in North Carolina, and they weren't citizens here. And they weren't even residents here, as a matter of fact. So there used to be people driving into North Carolina just to get a driver's license, even though they were from Georgia. Yes, sir.
While you're on that same subject, well, you have these Spanish people, and some of them are on the jury, let's say. Would you have to also have a Spanish interpreter, the
Yes,
English
sir.
interpreter there
Yes,
for
sir.
the jury?
Yes, sir.
That's not right.
And if you have a Hispanic defendant, we have interpreters.
I'm talking about, I'm on the jury and I'm Spanish.
If that juror says that they do not speak English, the judge is either going to have to let them go or get a, and the judge probably will let them go.
Yeah.
But as a technical rule, that will be raised one of these days too.
Yeah.
And I don't mean to be picking on Hispanics because.
I was getting into it,
Well, think about that. I mean, we get one or two Hispanic names on a Henderson County jury, for example, every time we pick a big jury pool, and if they show up, then I know that they're legal. But the ones that don't show up, you can presume that they're probably not citizens.
Just to sidetrack just a smidge, but still on the same thing. Would the American Indians still be a lot better off today if we had a stricter immigration policy?
I'm not going to get into it.
Okay, that's fine.
I'm not going to get into it. That's not part of tonight's.
I understand.
I wrote a couple of things down here this afternoon that I wanted to finish up with, but I think I've already done so. I wanted to alert you about the Racial Justice Act because it's offensive in its presumption that we're all automatically racist. And it presumes that all prosecutors and all juries and all judges are racist. And it creates that very close to a quota system that I hope we can avoid. It was bad enough, it was dangerous enough in employment law, but it's got no place in our criminal law. So I wanted to alert you, I don't know if all the DAs will support this compromise, but I'm just about to the point where I'm probably going to end up reconsidering and supporting the compromise so that we can get something better that won't be as damaging to our criminal justice system. Some people think that if they can discredit the criminal justice system overall by passing something like the Racial Justice Act, that they've helped their constituencies. And I don't understand that way of thinking, but apparently that's some of the thought. So now you know everything I know about the Racial Justice Act. It would be better off if it was repealed, but I don't think it's going to be able to get repealed because I don't think they're going to have enough votes to overcome Governor Perdue's veto.
And the fear is, with a great compromise, there will be no further action building up.
That's the gamble, and that's why the DA sat on their hands last week. And I'm kind of going through that mental dilemma right now. And I may get down there tomorrow and say to myself, let's gamble and see if we can repeal it next time and forget about that.
Well, it's a start in the right direction.
You need to know what I know, and now you know. So make up your own mind.
The message would be, I've got it written down here, pass the amendment to the Racial Justice Act and consider repealing it next summer.
Yeah, I think that's where I am on it. And that's after dealing with this since 2008.
And they're considering this thing like right now?
Yeah, they're in session tonight. This bill has been passed and read once in the House. No, it's gone through the House and now it's back with the Senate. So the Senate will be voting tonight or tomorrow on it. And if they make any changes, it'll go to committee or conference, they call it. If they don't make any changes and pass it, then it'll go to the governor for her signature and she'll veto it. And it looks like they'll be able to overcome the veto. So that's the ball score. Now, I really appreciate your letting me alert you to this, and you're listening to me for all these hours, seemingly, that I've been talking. I would hope that someday you'll invite me back to talk about something else that I love to talk about, and that is the constitutional right in our Constitution to do business without undue interference by the government.
Absolutely.
That is it's a very important fight that's being fought in Washington right now. I gave that talk in Charleston to a conservative group that meets once a month in Charleston. There's also the same group of guys meet once a month in New York City, and they're on tune with it. If you want to Google something, Google the New Age Ice Company case from Oklahoma. It's a 1932. I don't have that data, but I think it's New Age Ice. That sets out Justice Sutherland in that case wrote one of the best opinions that I've ever seen in 1932, talking about our right to do business without undue federal or state interference. I think it's called the New State. It's not New Age, it's New State Ice Company.
If we had any constitutional convention for writing or rewriting something, that Commerce Clause definitely needs work.
I want you to read, I hope you'll invite me back so we can
Yes,
look at
absolutely.
Justice Sutherland's thinking on that. And unfortunately, you know, the FDR court, he tried to stack the court after Justice Sutherland's opinion because they were so mad about it. And then the court got scared of FDR. And in 37 and 38, they wrote two opinions that really took a lot of the fire out of Justice Sutherland's opinion. But they didn't overrule it. They did not reverse it because of the reasoning was so strong they just diminished it. They didn't fully reverse it. So there are things in Justice Sutherland's opinion that we can argue today. And that fight is going on in Washington. When I ran for Congress, I was trying to alert people. That's the guts of what we've got going right now.
Well, it's wonderful.
Thank you, and hope to see you again when you need a speaker. Holler at me.